Again, we're taking your questions with our great legal panel. So if you do have any questions, feel free to post them on YouTube chat or on social media. Okay, so Sway, S-W-A-E, I hope I got this right. Dollars, D-O-L-L-A-Z, Sway Dollars, from YouTube says, G. Rossi, if the state loses, will the feds refile charges?
Well, practically, no. Academically, yes, because the double jeopardy clause is sovereign centric. If a state tries a case and they lose, the feds, even if it's a similar charge, identical, because it's a different sovereign, they can try him. But practically, no.
And just for me to round that out, Afi, I don't know how you feel, but I have seen instances in which the prosecution did not go well stateside and the feds decided to pick it up, like Gene says, on it's not double jeopardy because it's a different sovereign, and typically they're different charges like civil rights violations or things of that nature. What do you think, Afi?
Yeah, it's interesting. For some people, it's very unfortunate. I remember seeing a lot when I first started out, a defendant would be thinking he's getting a win because the state would unceremoniously dismiss a charge and he'd remain in custody, but only to have the matter picked up immediately by the federal government. So it happens all the time.
Yeah, and Gene, let me play this back with you because I think this is a good question, can be fleshed out a lot. I've also seen circumstances and been involved in them where we are the ones doing the investigation, we're the ones that build the case, we're the ones that file the charges, and the next thing you know, the feds come swooping in and file their own charges, and they wind up taking the case. That did not happen here, to my knowledge, in any way, shape, or form. This doesn't seem like the kind of case, if the government loses it on stateside, that the feds are going to want to pick up. A lot of witnesses, a lot of tangential pieces of evidence, and we know one thing about the feds: they never want to charge a case that they could possibly lose.
They can't win.
And you are absolutely right on that. There are a lot of prosecutors at the federal level who have an affliction called timidity. But here's the thing. I would say that given Afi just hit on a nail on the head, I think there's no sense that they're waiting in the wings. The feds are waiting in the wings. You know, I call it like a blister. They show up when the work's done. Once the state folks do all the work, they say, oh, we'll take it. That's happened. I don't see that occurring at all. And the main reason is this is a long trial, a lot of witnesses, a lot of transcripts that a prosecutor at the federal level will have to eat inconsistent statements. It's just a hot mess. So they're not going to go near it.
Funny, Gene, I never told you the story. I had one where we investigated for many months a bank robber who had robbed the plethora of banks, and we were going in to make the arrest. We did the right thing to call our partners and say, hey, I want to let you know we're going in and make an arrest. And our guys went and brought the guy out, and the next thing you know, a federal agency grabbed the guy and said, thanks very much, and they took him away and charged him. And we were like, literally took him out of the hands of law enforcement. That's how it can get. Okay, Afi, does, if the state loses, will YSL, and this comes from Purple Dinosaur, be able to be compensated for their loss of revenue?
So no, that would be a civil matter, and this is a criminal matter. I think the only way that I could see some type of claim if there was some sort of malicious prosecution. I don't think that that's anything that's viable here. So I would just say no. You know, I don't. Purple Dinosaur. That's a great question, but I can't see it. Gene, Bob, maybe you guys can help me out with that.
Yeah, I personally, Gene, I'm not going to see that. Prosecutors are given a tremendous amount of immunity and discretion, and that would have a significant chilling effect unless they could show there was a custom or practice, a policy of malicious prosecution, false arrest or something of that nature, which is very hard to prove. What do you think, Gene?
Well, I had to settle the case. If at the federal level, if you bring a case that is in bad faith or it is frivolous or both, and you have an acquittal or there's a dismissal, there's a federal statute that allows you to get attorney's fees. It's very hard, it's very difficult, but that's one remedy. but I don't see that here.
Yeah, and just to round that out, the statute you may be referring to is 42 U.S.C. 1983 and 1988. That is the civil rights statute, which again, if you are found not guilty as a favorable determination, and you could show that that injury was a result of a custom, practice, or policy, those are the real words, based on a decision named Monell, then you have a shot at it. But they're entitled to all sorts of qualified immunity. It's a very, very difficult prospect. But great question. Afi, does the prosecution have a case for witness tampering based upon a defendant being stabbed in custody? And that comes from 23F23 from YouTube.
Okay, so I'm assuming this is about the Shannon Stillwell Jackson issue. So you would have to do an investigation on the young man who allegedly stabbed him, and you'd have to look into, were there orders given? What is the reason? Was it just the result of a dispute in house? There's just so many things that they'd have to look into. I think that if there was a case for it, that would be. Yeah, they could do it. But for me, I would wonder if they could use that evidence to show that Stillwell is a part of a gang, and it's witness tampering, and it was maybe done by one gang member against another gang member. So I think that could help the prosecution in that way. Yeah,
I was thinking the same thing. Gene, this is an extremely deep and philosophical question, so be careful about how you answer it. Danny from YouTube says, since this case will drag out, should the judge respect the court's time more? And the reason I say it's deep philosophical is that the judge really is the court. But but not really. The judge is, but isn't. What do you think?
I'm a little confused by the question. Could you repeat it, please?
Yeah, since the case will drag out, should the judge respect the court's time more?
You mean respect the court's schedule? Is that it?
I think so, yeah.
Okay, let me tell you this. I know both of you have been in front of judges. I've said this many times. Judges guard their schedule almost as much as their own family members. It is a precious commodity. So at some point in time, probably March or April, this judge who I'm looking at right now, he's going to say, listen, I have a schedule, the jury has a schedule, I'm going to rein these prosecutors in, and I'm going to cut this trial by a month, maybe 6 weeks. There will probably be a moment in this trial when he does that. And I can't wait till it happens, because I don't care what kind of case it is, it shouldn't last 6, 7 months.
Afi, let me go to Alexa Rose. How are I think we talked about this a little bit earlier, but those who pled guilty, how is that going to affect the state's case?
So again, I kind of mentioned already about how we had the second defense counsel on an opening. He kind of already has planted the seed that these witnesses are going to be witnesses who are in Fulton County blue, and basically they'll say anything to not have to wear the Fulton County blue and to be free. So he's kind of planted a seed already to kind of discredit these witnesses' testimonies. But again, as Gene mentioned, sometimes jurors love what I call snitch testimony. It just depends on how they answer the questions, if there's corroborating evidence, and how they present themselves. So it really just depends.
And let me ask Chanel Holback, and let me go to you, Afi, on this as well. Is there any overwhelming evidence against Williams, like something heavy, quote unquote, murder, assault, felony possession, something that would be so-called RICO?
That's what they're alleging. We haven't seen anything yet, but we've got, again, hundreds of witnesses. But it's not, you don't need the heavy hitters. You don't need the murders. You don't need the armed robberies to be considered RICO. Any act in furtherance of the criminal enterprise can be considered RICO. And I think that's what the prosecution is banking on. They're presenting all of these small acts and saying that, hey, this is RICO. All of these things are going toward the furtherance of the criminal enterprise. But you're going to have to explain that to a jury who you're a jury member, you're a member of the public, but the jury, they think the same. We're all regular people. They're not going to understand that these tiny little acts are in furtherance of a gang. Like, we'll take the mall incident. Any jury member can discount that and say, hey, these are just people who don't know how to act in public, don't have the best home training, or we're young at the time, we're silly at the time. I don't know how this is going toward a RICO. So it's going to be interesting to see how the prosecution wraps that up, because most people associate RICO with heavy hitting crimes and violence, or, big drugs, big robberies, big murders.
Gene Rossi, you're a former federal prosecutor where RICO first came into existence, specifically with regard to the organized crime with mafia, and very, very, very effective tool. Some have questioned the use of RICO in charges like this. Does it set a precedent in your mind? And in your mind, does RICO apply, and are the facts here to prove a RICO?
I think focusing on this case, I think you have a quasi-enterprise, but I don't think you have a full-blown enterprise. And is that enough to persuade a jury? You have a lot of, interrelated dots. You have the mall incident. And Afi brought up a good point. Is this a person at the mall that's just having a moment of immaturity and recklessness? Or is this actually connected, and is it directed towards maintaining, promoting, and enhancing an enterprise? That's the key. Are they throwing in overt acts, I call them overt acts, RICO acts, that are wholly attenuated and disconnected, or they are part of a montage and a final mosaic? And that's going to be what the prosecution has to do in their closing, and show that it's a mosaic, not some box of pieces of a puzzle that are unrelated.
Well, DC71 Gene from YouTube wants to know that if these RICO charges in Fulton County are in fact successful, would it set a precedent?
I don't think so, and I'll tell you why. RICO cases are very hard. They're laborious. They last long. I don't care if it's the federal level or the state level. So it's not going to change the desire of prosecutors to use RICO or to stand down. If there's a case for RICO, they will charge it. It won't have anything to do with this case. I will say this. This case is proving that if you're going to bring a RICO charge, you better be organized, you better be efficient, and you better persuade that judge that you know what the heck you're doing.
Yeah, interesting. Afi, DC71 also has, I guess, a pragmatic question. Do you think that if a state paid jurors $50 to $100 a day, that would speed up the trial? I think so. Now, I'm not sure what he means by, or what she means by speed up the trial, but money in jurors and what they're being paid is always an issue that comes up. So what are your thoughts as it relates to this case and that question?
Yeah, that's a great question. I don't know that it would speed up a trial, but I think it's important to understand the plight of the jurors, and you need to take care of your jurors, because you want to always have an engaged jury and people who want to be present, because you don't want them voting or commenting or being disengaged because they're worried about their jobs, they're worried about their homes, they're worried about picking up children, how they're going to put food on the table. You need to protect and take an interest in your jurors. Also, it really, I think it just really changes the dynamic and the makeup of a jury, because you're looking at people who have to be at work at certain hours or who don't have to be at work at all. So, what's the strata of what are your jurors looking like? Are they really juries of your peers at that point? So I think it's something that needs to be addressed across the nation. Like, you have to give jurors more than lunch. You have to give them more than 50 cents or 75 cents a mile for gas. You have to take care of them so defendants and at the state can get a good representation, and the defendants can get a jury of their peers.
All right. Now, Gene Rossi, James Bond from YouTube wants to know, what rights did co-defendants that pled guilty to give up? And I'm trying to see, and do they still have a right to not take the stand?
No. If they give up their right, if they don't take the stand, then their plea agreement is going to explode like a volcano. When they plead guilty, they are giving up the right to appeal any conviction, right? Number one. Number two, they are agreeing to cooperate. So if they have this epiphany the day before trial, the morning of the trial, and say, you know what, I pleaded guilty, I signed on the dotted line, but I don't want to cooperate, they're going to blow that plea and they will be charged with all the crimes that were dismissed or that were failed to be prosecuted.
Yeah, very, very interesting. All right, let's go to you, Afi. We have about 40 seconds to answer this question. Danny from YouTube wants to know, should these 6 defendants be put in protective custody to avoid the chance of what happened to Stillwell?
You know, I think we talked about this earlier. You know, what can the prosecution do, and what can the defense do? Like the Department of Justice, you know, and when you're dealing with the prison system, it operates differently from, you know, our judges and our attorneys. So I think that it's in the defendant's best interest to try and talk with whoever the warden is over the prison to put them in a separate area while this is happening. I've had to go and talk to wardens myself personally on behalf of my clients. So, yeah.
Yeah, no, very, very difficult